check real quick.
It's 9:05 on Wednesday, March the 24th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Beck, Curcio, Farmer, Griffey, Hardaway, Howell, Lamberth, Moody, Russell, Sexton, Chairman Doggett. Mr. Chairman, you have a quorum.
Thank you very much. Before we begin today, a good friend, another chairman of a full committee, starts his day off with a day in history. And I'm not trying to copy that man by any means, but today in history, some time ago, we are in service, yes, sir. But this day in history, some time ago, and I don't know the exact date, but there was a baby born, and he is celebrating his birthday today, and he might just be sitting right over here, our Sergeant of Arms, Mr. Reuben Sanders. Happy birthday to you. Any other members have any personal orders? Representative Griffey.
Thank you, Mr. Chairman. I'd like to recognize two of my constituents and people that have relatives that are constituents of mine that are here to discuss about the GPS monitoring bill. Jessica Jones, who lost her sister in 2018 to domestic violence, and Amanda Allen, who lost her sister to domestic violence in 2020, I believe, spring 2020. So I just want to recognize both of them. Thank you, Mr. Chairman. Thank you both for being here.
Thank you. Any other members? Seeing none, we are going to dive right in. Before we begin with our first item on the calendar, we're going to go through and go through a few things here. Item number 3, House Joint Resolution number 44 by Chairman Hazelwood has been rolled 2 weeks. Item number 5, 1062 by Chairman Hawk is rolled 1 week. Item number 10, 1143 by Vice Chair Grills is off notice. Item number 13, House Bill 629 by Representative Gillespie is off notice. Item number 18, House Bill 1480 by Vice Chair Parkinson is off notice. Item number 26, House Bill 592 by Representative Clemens, roll 1 week. Item number 25, House Bill 413 by Representative Lamar. Roll 1 week. Item number 32, House Bill 1159, Representative Stewart, roll 2 weeks. Item number 33, 1160 by Representative Stewart, roll 2 weeks. Item 34, 1316 by Representative Stewart, roll 2 weeks. 34. Item number 35, 1574 by Representative Stewart, roll 2 weeks. Item number 46, House Bill 803 by Representative Griffey, roll 1 week. Item number 43, House Bill 1313, Vice Chairman Sexton, off notice. And I believe that's it. So without any further ado, we'll go with item number 1, House Bill 1187 by Representative Garrett. You have a motion and a second. You are recognized.
Thank you, Mr. Chairman. Committee, House Bill 1188 seeks to enhance public safety by requiring certain high-risk DUI offenders to only operate a motor vehicle equipped with an ignition interlock device as a condition of bond. What the bill does, it targets high-risk offenders, those that are caught driving under the influence with a prior DUI conviction, with a minor in the vehicle, and other vehicular assault, aggravated vehicular assault, etc. So what this does is, as a condition of bond, if they have those certain charges, they have an interlock device placed on their vehicle so they cannot recommit.
Point of order, Mr. Chairman. Mr. Chairman?
Yes.
Point of order.
Yes, sir.
Are we on 1187 or 1188?
We are on House Bill 1187, which is.
I thought I heard 1188.
This does with electronic.
I've got it as 1188.
Item number 1 is 1187. Is what we're on here. Electronic. Yes, sir.
Point of order. Maybe in the wrong bill, but it was still an excellent speech.
It is an excellent speech. Would you?
So we're on the electronic communications.
We are on
Okay.
electronic
All right.
communications now.
Wow.
Before
1187.
I tell you what, if you don't mind, well, I don't know how to do this, but we're going to do it. We'll get a motion and a second on House Bill 1188. Motion. Second, and now you can go back on what you just. Thank you. Continue.
Okay. Thank you, Mr. Chairman. I apologize for the confusion. So with that explanation, I'll be happy to take any questions on House Bill 1188.
Any questions for our sponsor, Representative Beck?
Thank you, Mr. Chairman. And to the sponsor, Chairman Garrett, what is the law as we stand here now on the interlock device?
It's not a requirement of bond, as I understand it. This would make. I promise I didn't do that. As I understand it, it's not a requirement of bond to have an interlock device as we stand here now. So what this will do is if you have a DUI second conviction, it'd be a requirement of bond. And also, if it is your first time for a DUI, but you have another potential conviction, like you have a minor in your car, this would invoke this requirement under bond as well. So that's what this bill does.
So it's permissive as it stands today, and you want to make it a requirement. Is that?
That's right.
Okay.
Now, to address that, though, in case there's some circumstances where the judge doesn't feel like it's necessary, the judge has that discretion not to order it, but there's got to be certain circumstances to take place in that circumstance. I do have some here to testify. If I could have her tell her story that might shed some light on the reason why this. Her name is Phaedra Olson. I believe she is on the list.
Okay, yes, we do have her on the list. Without objection, we will go out of session to hear
Thank you very
from Ms.
much.
Olson. Madam, when you before you begin, if you will introduce yourself, tell us for the record your name and organization you represent, and then you'll have 4 minutes for testimony.
Make sure I've got it on for you.
Thank you. I think we're good.
Okay.
Thank you so much, Mr. Chairman. And the members of this committee, my name is Phaedra Marriott Olson, and I am the State Program Director for Mothers Against Drunk Driving. I'm here today, like so many other people that have joined MAD, because I myself became a victim of a drunk driving crash. In 1996, a drunk driver crossed the center lane of the highway, and he hit my car nearly head on. From that crash, I sustained many, many injuries. But the most catastrophic thing that happened to me was due to the impact of the crash. My aorta heart valve, we just hit so hard that my aorta heart valve was actually ripped away from my heart. And at the age of 22, I was taken in for open heart surgery. During that surgery, I was bleeding to death. I was dying. The physicians did the only thing they could do to be able to save my life. They shut off the blood supply to my lower extremities, and it left me to be paralyzed for the rest of my life. I will spend every day from this seated position. And with that, the only thing that we can do is to be able to make our highways, our roadways, and our community much safer here in Tennessee. And we can do this with the support of this bill. You see, in 2006, Matt actually launched the campaign to eliminate drunk driving. And part of that initiative was to be able to reduce ignition, or to be able to reduce drunk driving fatalities and crashes across our nation. But specifically, part of that program that we work with is working with ignition, all offender ignition interlocks. Now, Matt decided to put faith in our interlocks for every single drunk driver, as this is the only tool that can physically separate drinking from driving while teaching sober driving. We found that license suspension alone definitely does not always work. But what we do know is that when it comes to ignition interlocks, we have a 67% more effective rate in reducing repeat offenders compared to licensing suspensions alone. So in 2013, our great state of Tennessee and the work that you all do actually enacted an all-ignition interlock program here in Tennessee. However, like many states, what we see with ignition interlock bills is that sometimes we have individuals that fall through the loopholes. However, we also know that this House Bill 1188 does fix this loophole when it comes to retaining our judicial discretion. From 2006 to 2019, these devices actually stopped over 26 million attempts for drinking and driving, 3.4 million attempts to legally drive drunk with a BAC of 0.08 or higher. In Tennessee alone during this time, ignition interlock stopped 513,000 drinking and driving attempts and over 69,000 attempts to legally drive drunk with a BAC of 0.08 or higher. Mr. Chairman and the committee, please advance House Bill 1188 to keep our communities safe here in Tennessee. Thank you.
Thank you very much. I have a couple on our list. Do you wish to talk with our witness, Leader Lambert?
Pedro, it's just so very good to see you today. We've been friends for many years, and I just, you're one of the bravest ladies I've ever met. I just appreciate you coming down here every year and fighting hard to make sure that we have no more victims. And so thank you for your testimony today, and it is extraordinarily good to see you.
Thank you, Representative Lambert.
Representative Russell.
I just want to thank you for being here and just tell you you're making a difference, and I appreciate what you do. Thank you.
Thank you.
Representative Hardaway.
Thank you, Mr. Chairman. Good morning, ma'am. I admire your courage. I appreciate you being here and sharing the data, the statistics. Your messaging is on point. It's unbelievable how, if we listen to those who are on the ground and doing the work, it's unbelievable how much of a difference we can make in the lives of our citizens. If I believe your numbers were 500,000 or so attempts by those who are on bond or under the authority of the courts to drive drunk after they've been caught doing it. So that this bill makes more sense than before, and I absolutely will support it, and I urge my fellow committee members to vote in the affirmative, and I thank you again for, as it's been expressed earlier, your courage, but also your effective messaging in helping to advocate for a better way for us to address this scourge. Thank you. Thank you, Mr. Chairman.
Thank you.
Thank you. Any other members? I will say thank you for being here. Thank you for your testimony and for the work that you do.
Thank
Greatly
you so
appreciate
much.
it. Thank you so much. We're going to go back in session. We're back on House Bill 1188 by Representative Garrett. Are there any questions or comments for our sponsor?
And since I've started on the wrong bill, I don't believe there's any more that I can demonstrate more than you did today. So thank you very much for your testimony. So demonstrate the need for this legislation. So.
Thank you. Any objection to the question? Seeing none, we're now voting on sending House Bill 1188 on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. Move on to full criminal. Thank you.
Thank you, Mr. Chairman and committee.
We're on item number 1, House Bill 1187 by Representative Garrett. We'll need a motion and a second on. All right, you're properly recognized.
Thank you, Mr. Chairman and committee. This legislation was brought to me by the DA's conference, and in most criminal investigations, digital evidence is important and needed for just about every case nowadays. It's very often to obtain data directly from these digital carriers, such as Verizon or AT&T. And for example, in human trafficking cases, it is common for these folks to use cell phones to communicate through social media and chats to negotiate, believe it or not, for the price of a potential victim. That conversation or data is needed to corroborate the victim's story of what exactly happened. Criminal investigators accomplish this by getting search warrants for the data that is control and possession of the digital company like Verizon that may not be located here in Tennessee. Currently, there is no Tennessee statute that clearly authorizes the Tennessee judge to issue a search warrant for data that may be stored in another state. There is, however, a current federal statute that does give state judges this authority, but some recent local courts have been raising some issues with that. So we need to clarify the state statute that Tennessee judges can issue subpoenas and search warrants for stored information that's not located here in the state of Tennessee. So what this legislation does is it basically mimics the federal law, codifies it here in Tennessee, so if there's information stored on a device that's stored not here, but in another state, this will allow us to reach that information in a situation like a trafficking situation. So that's what the legislation does. Mr. Chairman, I'll be happy to answer any questions.
Thank you very much. Any questions for our sponsor? Representative Hardaway.
Thank you, Mr. Chairman. And I thank the sponsor for the bill. Is this bill in response to issues that the DAs have had in securing evidence from the large carriers in particular? That's what I heard earlier.
Mr. Chairman. Thank you. Yes, some courts aren't honoring the subpoena or the search warrants because we don't have a state statute that specifically authorizes the judge to issue that, even though there is federal law. But some cases are federal cases, some cases are state cases, so it just gives the authority for our judges to issue those subpoenas in other states, so the judge will hopefully comply with that state-issued subpoena.
And without it, it's impeding criminal investigations.
Absolutely.
All right. Thank you, sir. Thank you for the bill.
Thank you, Representative Beck.
Great, thanks. Just out of curiosity, since I don't do criminal law, who do you, and I know don't do criminal either, but who do you hold in contempt, is there the keeper of the records? I mean, who do you hold in contempt if they don't comply with, if they're out of state?
That would be applied under we have no long-arm statute, so we have no authority to even go that route. This would at least allow us to have a potential contempt under a long-arm statute for the company that's doing that in California, New York, or Wyoming, or wherever this data is. So it at least gives us that power under the statute to do that. Right now, we don't even have that because it's not a statute that the Tennessee judges clearly have the power to issue that subpoena.
So after this becomes law, then we'll see who we can hold in contempt.
That's right.
Is that what you're saying?
Excuse me, Mr. Chairman.
Very good. Thank you.
You're welcome.
Any other questions? We do have someone here to testify if they are needed.
Sure.
Do you
they are
wish,
here, I would like for them to be able to testify.
From the District Attorney General's conference?
Sure.
You don't? Okay.
Oh, you're good? Okay.
They say they're fine?
They're good. Okay.
All right.
I think we're...
Well, all right. Any other questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 1187 on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We'll move on. Thank you.
Thank you, Mr. Chairman. Committee.
Members, we are going to skip in the calendar here. Item number 36. Item number 36, House Bill 217. We have a motion And a second, you're properly recognized, Chairman Curcio.
Thank you, Mr. Chairman, and I want to also say thank you for taking up some of these bills. I certainly didn't ask for that privilege, but I'm honored to be brought up, so thank you very much for doing that. I do have an amendment coded 3922.
Okay. A motion.
Like to move that.
Second on the amendment.
Thank you very
Proceed.
much. If you'll recall, several weeks ago, we had much debate on this bill, and what this amendment would do is it would delete sections 1 and 6 and then just renumber the remaining sections. So it's going to take out the bit about the criminal monitoring fund and just leave in the original core of the bill, which was the bounty hunter provisions.
Question has been called on the amendment. Any objection? Seeing none, we're now voting on adding amendment number 003922 on the House Bill 217. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We adopt. We're on House Bill 217 as amended.
Question on the bill.
Question has been called. Any objection? Seeing none, we're now voting on House Bill 217 as amended. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full criminal.
Thank you, Mr. Chairman. Thank you, committee.
Item number 37, House Bill 888 by Chairman Curcio.
Thank you, Mr. Chairman, and I again have an amendment that will rewrite the bill.
I will need a motion and a second on the bill itself. We have the motion. We have a second. Second. All right, amendment number 004783.
Yes, sir, that is correct.
Have a motion on the amendment.
A second.
Have a second. Okay, proceed.
Thank you, Mr. Chairman. Thank you, committee. So what this bill seeks to do is it builds on some success that we've had with the expungement statute in Tennessee. So we were actually leaders in this, despite what you may hear from folks outside these chambers. Tennessee really led the way on expungement several years ago. A lot of times, Leader Lamberth and I will joke, we'll have these kind of over-caffeinated consultants come to us from other states and talk about their Fresh Start legislation where you can finally get a misdemeanor expunged in XYZ state. Tennessee actually led the way, and we actually allow E's and 1D felony to be expunged. Now, none of them are violent crimes. They're all nonviolent, non-sexual related. And so we've watched this for a number of years. And what we talk about a lot around here is how incremental progress is progress, right? Let's not jump into the deep end on something. Let's try something. If it works, let's try and build upon it. And so that's the spirit of this legislation today. I have worked extensively, I will say, with the District Attorneys General Conference on this to try to make it in a way so that we're taking a nuanced and a tailored approach, and I want to thank them for their efforts on this as well. But what this bill would do is it would expand the current list of expungible offenses, but it does not change the structure of how it works. So it's still one bite at the apple. And there's a length of time that is built in some cases up to 15 years before you can have that offense expunged. We've also created some safeguards, which I can talk about, allowing the DAs to weigh in. So if they've got a pending indictment or something on somebody, but they don't need to bring that out publicly, they can meet with the judge in camera and present that information to them so that they don't tip off somebody who may be, in for a bad weekend. So we've worked very, very hard to make sure that this is tailored, but we think we're building on some very good success in Tennessee. And with that, I'd be happy to answer any questions about the amendment.
Any questions for the sponsor on the amendment? Representative Beck.
Thank you, Mr. Chairman. And sponsor, I'm going through the list of E and D felonies that we're now going to allow to be expunged. And a lot of them seem to be fraud, worthless checks, counterfeit home improvement fraud. Let me ask you a question. If I'm an employer and I am running a background check for somebody who's going to be handling a lot of money, and they have an expungement and they've stolen hundreds of thousands of dollars in the past and have an E or D felony, I'm now not going to be able to learn that they have a history or a propensity to steal. Is that correct?
Thank you, Mr. Chairman. The list that you're reading is actually the current expungable offenses, so that's not changed by the bill. And the amendment, what we're doing is we're expanding up the ladder on some of those things. But again, you'd have to have, so for the current E's, it's a 5-year waiting period. So once you've served your time, paid your restitution, paid your debt to society, then you've got to go 5 years without any further issues whatsoever. Then you can petition the judge. Doesn't mean it's going to be granted, but you can petition the judge for an expungement. The way it works for the D's is that it's 10 years. So again, once you've served all of your time, paid your debt to society, paid your fines and fees and your restitution, and you've gone 10 years without any blemish at all, then you can petition the judge. And again, the judge can still absolutely turn that down. And in this bill, the DAs would be able to weigh in to say, no, we've got further information on this person that needs to be considered. And up the ladder. When you get up to the A's and B's, it's a 15-year waiting period. So if you're, as you know, as you practice in the law, if you serve time for an A felony, nonviolent A felony, you're going to serve 15 years in prison. Then you're going to have to go 15 years as a complete Boy Scout with no blemish on your record whatsoever. And then you will be able to petition a court, and there's no guarantee that it will be granted. So if you offended in your mid to late 20s, add 30 years to that for the opportunity to ask a judge if maybe you could have it expunged. So it's a very, very tight window, but what I'll say is that every year when the General Assembly convenes, I have a line of members at my door telling me a story about someone in their district. They'll say, I go to church with a man, he's got a wife and 3 children, daughter's a doctor, son's a lawyer, has done everything right, but in his early 20s, he screwed up. And he just wants to live out the remainder of his days on this earth and go to the good Lord with a clean conscience to know that he has paid his debt to society, to the state of Tennessee. And so this, I think, provides, albeit a narrow window, a window for folks like that who have truly redeemed themselves and want to be able to kind of live out their days knowing that they paid their debt to society.
Thank you for that explanation. But I'm looking on here, so where is the list of, is it in your amendment or in the bill for the E's and D's that we're going to now let be expunged?
So in the amendment coded 4783, starting at the bottom of page, it's be in section 10. A person who was convicted of one of the following Class D felonies committed after November 1st, 1989. And again, if you recall how the current expungement statute works, it's one bite at the apple, and you can't do it for multiple felonies unless they were part of the same, criminal activity or the same charge. So if you've got somebody who has a history, who's a chronic habitual thief or something like that, they're not going to be eligible for this. These are folks who made a mistake and are trying to put their lives back together years and years in the future. I will also say that in one of the additions that we worked on with the District Attorney General's Conference, which I welcomed, is that for the A and B felonies, there's a rebuttable presumption that the expungement should not be granted. So on those highest levels, even though there's been, again, in this case, 30 years that has transpired, they're still going to take a hard look and say, has this person's behavior truly changed?
Thank you for the explanation.
Thank you, sir.
Representative Hardaway.
Thank you, Mr. Chairman. To the sponsor on section 1 and 2, the clerk may charge a fee of up to $100. Clarity on that. So does that mean that it's at the complete discretion of the clerk, or is there a schedule elsewhere in the code?
Thank you, Mr. Chairman. I'm so glad you asked that because I skipped over a very important piece of this legislation that I think you will be glad to hear about, Representative Hardaway. Several years ago, we waived the fee for that the state charges for expungement. And when we talked about that, if you look at the legislative history and the legislative intent and our debate, we said by wiping out this state fee, the local clerk still may charge a fee or may not charge a fee. We obviously hope that they don't, but if they have to, we understand. Well, we were wrong. What we didn't realize was the code as currently written requires, it says the clerk shall charge a fee. So what that section of the bill that you're pointing to does is it changed that shall to a may. So that way, if there are clerks who are also trying to increase access and not, find somebody or have them charge them a fee where they may not have the means to be able to pay that or create additional financial barrier, we want them to be able to waive that if at all possible. Thank you for asking about that.
Thank you for that clarification. Thank you, Mr. Chairman.
Any other questions for a sponsor on the amendment? Seeing none. Any objection to calling the question on the amendment? Seeing none. We're now voting to add amendment number 004783 on the House Bill 888. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We adopt. We're now on House Bill 888 as amended.
Thank you, Mr. Chairman. I renew my motion.
Any questions for the sponsor? Seeing none. We're now voting on sending House Bill 888 as amended on the full criminal. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. Move on to full criminal. Thank you.
Thank you, sir. Thank you.
Next item, number 38, House Bill 744 by Chairman Curcio.
Thank you, Mr. Chairman.
Recognize.
Thank you very much. Thank you, committee. This is actually a bill that I'm carrying in conjunction with the District Attorney General's Conference, and something I'm very proud to be able to do. We've talked about this for a number of years. We're not able to make it work before now, but hopefully, and with the wisdom of this committee, we can move this idea forward. What we're going to do here is establish a grant program in the DA's conference to award grants to county governments for the purpose of assisting with the creation of a dedicated, accessible, safe, and secure place for victims to meet with their attorneys. Any of you who've been to your county courthouse know it's a busy, bustling place. Where I live in Dixon, Tennessee, in Charlotte, we actually have the oldest working courthouse in the state. We just built a brand new Justice Center, which we're very proud of. But before that Justice Center was built, you were in a courthouse that had been standing since James Robertson named the county seat after his wife. And so there wasn't a lot of space to move about. So if you'd been victimized, you were quite often in the same hallway, in the same area with that person who made you a victim. And so I think it's important, and I'm proud to be able to carry this to create a safe space that's secure and accessible where those victims can meet with their attorneys.
Thank you. Any questions for our sponsor? Chairman Moody.
Not so much a question, but thank you for your consideration of the victims and how awkward and uncomfortable and distressing that would be. Thank you.
My pleasure. Thank you.
I agree with that. Thank you. Any other questions? Representative Hardaway.
Thank you, Mr. Chairman. To the sponsor, initially there was some question from the DA's conference on whether the rural areas would have the adequate funding. Are we helping them to pay the costs for whatever modifications might be needed?
Thank you, Mr. Chairman, and thank you to my good friend from Shelby County for the question. So this would authorize counties to receive a one-time grant of up to $5,000 with a match requirement of at least 25% of the amount requested. So if they request the full $5,000, they would have to put up 25% of that or some amount lower if they did not request the full $5,000.
Okay, is there a second funding option if that $5,000 is not adequate?
Thank you, Mr. Chairman. No, sir, the bill doesn't contemplate that. We tried to balance our what we're trying to do for victims with obviously budgetary constraints and the realities that we see. But all the bill would say is that it's a $5,000 grant, and the local match requirement is only 25% of whatever amount that they request.
And would there be any liability for that county seat or the courthouse or whoever's administrating if they did not do this and there was an incident?
Thank you, Mr. Chairman. So I think your question is, well, let me restate the question, make sure I've got it right. Are you asking if they draw down the funds and then never build the space, we'll be able to claw the money back? Is that the question?
No, sir. Whether they draw the money down or not, if they fail to follow the directive to build the space, period.
Thank you for the question. I understand now. There is no directive to build a space. Some county seats already have a victim space in their courthouse. So it's not our, we don't believe that all 95 counties need this. I mean, for example, in Shelby County, you've got a much larger setup than what I described, say, in Charlotte, Tennessee. Although, again, we have a brand new Justice Center, which we're very proud of. But before that was built, we didn't have a lot of room. So not everybody needs this. What we want to do is we want to help the least of these who do need the most help.
And Shelby County is in a position to handle the requirements, and I'm trying to look out for my rural brothers and sisters. Thank you, Mr. Chairman. Thank you.
Thank you, sir.
Thank you. Any other questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 744 to full criminal. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. You move on. Thank you.
Thank you, Chairman. Thank you, committee.
Item number 39, House Bill 325 by Chairman Curcio.
Thank you, Mr. Chairman. And thank
Motion
you for
second.
that. I do want to just say, this was an idea that I'm very passionate about. I know Leader Lamberth and others and I have worked on the criminal, the Indigency Monitoring Fund, known as the EMIF, and how that interplays with Interlock and so forth. We have a system right now that, unfortunately, every year runs out of money through no fault of anyone who's administering the plan. And so we thought we had a fix here, but have heard from FNA that this is not something logistically that they can do this year. And so out of my high regard for the executive branch and in the spirit of wanting to make sure that we move forward to work together to create a workable solution for Tennessee, I would request this bill be taken off notice.
Thank you very much. Thank you for your work on this. But without objection, we will take this off notice. Thank you.
Thank you, Chairman.
Item number 40, House Bill 1440.
Motion.
And properly recognized.
Thank you, sir, and give me just one moment. Thank you, Mr. Chairman. I apologize. I just needed to get my notes in order. I do have an amendment coded 4756. It makes the bill.
We have a motion and a second. You're recognized on the amendment.
Thank you very much, sir. Members, what we're trying to do here is kind of modernize our code when it comes to certain drug weights and types of drugs. As we know, fads and things change over time. We hear a report almost every year from the TBI over what the largest drug crimes are in the state and kind of what our real problems are. So what I wanted to do is I sat down with our friends in law enforcement and said, okay, if we really want to try to separate dealers and traffickers from petty users and try to right-size our system a bit, what would be some ideas to do that? And this was something that we came up with. So what this bill would do is it increases the threshold on the Class B felony enhancement for manufacturing, delivering, selling, or possessing with the intent to manufacture, deliver, or sell cocaine from 0.5 to 3.5 grams. Cocaine was once a much larger problem than it is now, and by doing that, what we can do is we can lower the threshold on some Class B felony enhancements for things like amphetamines, fentanyl, and carfentanil, alfentanil, tyfentanil, and all these other fentanyl derivatives or analogs from 15 down to 10 grams. So what we're doing is we're gonna try to tighten the screws on folks who are trafficking the drugs that we see most currently now, and take away some of the, or rather re-divert some of the resources that we're putting towards those cocaine users that are not really trafficking in large amounts. So it's kind of a right size of the code. And if you've got any questions about why the specific weights for each one, I'm happy to answer that, but I'll leave it at that.
Thank you. Any questions for our sponsor, Representative Beck?
Thank you, Mr. Chairman. Thank you, sponsor. Is there any discrepancy between crack and powder cocaine under your amendment?
Thank you, Representative Beck, for that question. I don't know if the code doesn't change the definition. I think cocaine is just mentioned as cocaine in this bill.
Very good. Thank you.
Thank you.
Any other questions? Representative Hardaway.
Thank you, Mr. Chairman. And following up, I was coming along the same lines as Representative Beck, because we know in the poor communities, it's crack that's filling up the jails and ruining lives. But the users need more health care than criminal care. So I want to try to be straight. Are we impacting the sentencing for the users, the charging or the sentencing of the users of crack cocaine?
Thank you, Representative Hardaway, and I wanted to make sure that I had this answer right for you because it's certainly my legislative intent. But no, you and I are onto the same exact issue. The Tennessee Code does not differentiate now. Cocaine includes crack, powder cocaine, and that's exactly why we're going from 0.5 to the 3.5, because at 3.5 grams, you're just below 1/8 of an ounce, which law enforcement regards as a dealer amount of cocaine. Any amount below this threshold that the bill is now creating should be considered possession by a drug user rather than a drug dealer to be punished as a Class C felony similar to other Schedule II substances. So I think it rights the multi-year wrong.
All right, and is there any intent in this bill or future legislation to make sure that we're not only addressing the law enforcement issue on the streets, but addressing the health care issue that follows this?
Thank you for the question. This bill does not contemplate health care in any way, but I'm sure the Health Committee is working hard on those issues as well.
All right. Thank you. I think we need to be more comprehensive in how we approach our criminal justice reform, and on those issues which require intervention, prevention, and intervention, that we're compelled to make those options available to our citizens. Thank you for the legislation, sir.
Thank you, sir.
Thank you, Mr. Chairman.
Thank you, Representative. Representative Griffey.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing the bill. And regrettably, I can't support it. And I just want to say this. Look, I've been a defense attorney for about 30 years now. And in my experience, both in Memphis, Shelby County, state court, federal court, and in rural Henry County, Benton, Dover, Tennessee, when a defendant comes before the court on drug possession with intent to distribute, that person's record is thoroughly looked at and reviewed, and there are always, and this is my experience, always multiple convictions, times, and efforts by the DAs, the judge, and the court to try to get the person some help and get them off drugs. And when a person finally does get a sentence, it's kind of at the end of the rope, where they're like, you've had 1, 2, 3, 4, 5 strikes at it. Sorry, you're going to have to face the consequences for your continued drug use and drug dealing. And to me, this bill is simply lowering the bar and being softer on crime rather than holding people accountable. Drugs are the most problematic issue for society today. And look, I'm all for getting drug assistance for everyone, more mental health in the criminal justice system. That is definitely needed. but simply lowering the bar, in my experience, is unproductive. And for that reason, I can't support the legislation. Thank you.
Thank you, Mr. Chairman, and I appreciate those comments. I do want to point out, and I'm not to be in a running debate at all, but just so nobody's unclear, this would still be a C felony. So it's not like we're decriminalizing anything here. And of course, those other factors that you mentioned would also be able to be taken into consideration. The history here, I think, is important. As part of the war on drugs, Congress passed the Anti-Drug Abuse Act of 1986, which, as we all know, disproportionately increased penalties on crack cocaine over powder cocaine, which we talked about earlier. And unfortunately, our state followed suit 3 years later, passing the Tennessee Criminal Sentencing Reform Act of 1989. And while the Tennessee Code does not distinguish between crack cocaine and powder cocaine, the Sentencing Commission recommended and the General Assembly adopted a 0.5 gram threshold for treating cocaine as a Class B felony, whereas all other Schedule II drugs were treated as Class C felonies. So we're just trying to treat this the same way we treat other drugs in the same category. And I want to applaud our former president, Donald Trump, who signed the First Step Act on December 21st, 2018. And now this bill will bring Tennessee in line with where President Trump really felt like our state should be. So thank you very much.
Thank you. Any other questions for our sponsor on the amendment? Seeing none. Any objection to calling the question on the amendment? Seeing none, we're now voting on adding amendment number 004756 on the House Bill 1440. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We're now on House Bill 1440 as amended. Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 1440 as amended on the full criminal. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. You move on to full criminal. If you wish to be recorded as a no, please see the clerk. Members, let's take a journey back to the front of our calendar to item number 4. We're going to House Bill 978 by Chairman Williams. You have a motion and a second. You are recognized.
Thank you, Chairman and members. House Bill 978 is comes to me from my local community. We have, as some of you may know, when you travel east, there are 5 exits in my community, and our Putnam County is shaped similar to the state of Tennessee. It's long and narrow, so we have lots of interstate access, but and so that's where most of the 8 counties come there to shop. We have, years ago, we passed a statute for camping that says you can't camp on state properties. What this bill does is seeks to extend the same camping prohibition at the local level for municipal and city governments. Currently, they're not able to prevent people from camping on public properties. For instance, there's a bus garage in my community, and people have begun to camp there. And so this would allow them a Class C misdemeanor on those divided access highways as well as the city-owned property. With that description, I'm happy to answer any questions. I know in communication with the chairman and his communication with legal counsel, there might be a little bit of a concern, and I hope maybe with her wisdom maybe to answer it.
Any questions for our sponsor? Representative Russell.
Thank you, Sponsor. I just want to clarify, that's a Class C misdemeanor?
Yes, in Section C, it says a Class C misdemeanor.
Thank you.
Any other questions for our sponsor? Representative Hardaway.
Thank you, Mr. Chairman. Sir, I'm not going to be long, but I can't support a bill that in essence is criminalizing those who are homeless, poverty-stricken. In some cases, maybe they have mental or intellectual disability or challenges. And the irony is that if I'm reading the bill correctly, someone that has no money is being fined $50, and someone who's out of work is compelled to do community service work for free. I just can't support that. So if I'm misinterpreting, please help me. But otherwise, it just looks like we're criminalizing, and I don't know if felonizing or felonyizing or however to put it. But yeah, whatever that word is, we're putting a criminal burden on folks who, instead of slapping them down, we need to be trying to reach that hand out to pull them up. So I'm interested in your response, sir.
Thank you. As the question said earlier, this is not a felonious event. Secondly, as it relates to this, it's already in current statute. Local governments can't do that. Do not have the same rights or privileges. The reason for including community service was so that we could find another way, but we have to have some way of having an actionable offense in order to be able to help these folks. In addition to this, though, you commented about mental illness. I think it's a really important component of the challenge that's in my community and across the state. And so there are other bills that I have that deal with those issues. For instance, eliminating the certificate of need process for mental health components in rural parts of the state. It's very difficult for people to do that. And so I have a bill to do that as well. But it's a multifaceted approach, and this component of it here happens to be as it relates to the criminal penalty. The truth is that my local law enforcement, sometimes much like discipline with our kids, the ability to discipline doesn't mean you want to, it just means you have an action to do that. So if law enforcement's able to say, we can get you the help that you need, but you can't do this, that's why this bill is necessary.
Okay, and I know where your heart is, and I don't question your intent, and I'll probably be signed on to a couple of your other bills. This one, I might have a change of mind pending our discussions by the time it hits full committee, but in subcommittee, I'm not there. But thank you, sir.
Thank you.
Thank you, Mr. Chairman.
Chairman Curcio.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing the bill. And we talked about this again last night, and because I initially had some of those questions that were just talked about, but I think you've satisfied them here. And for me, the operative piece here is in Section 1. It's unlawful for a person to solicit from the roadway, shoulder, or berm or right-of-way of a controlled access highway or entrance ramp of such highway. So think about the interstate. If somebody's panhandling or camping on the interstate shoulder, that is a public safety hazard, not only for the drivers, for the person who's doing that. Unfortunately, I had a man in my district who was killed that very way, and just tragic set of circumstances. But, as far as what we know this bill does not contemplate, somebody that you might see at an intersection asking, for change or something like that. That's not the intent here, and I don't think you touch that. So.
No. Thank you, Chairman. Yes, Chairman Curcio, that is not the intent with this bill. As the courts have opined and the Supreme Courts have opined that panhandling or solicitation in public property is a First Amendment right, they can do that. This is much like the statute, if most of us have seen people walking along an interstate highway, hitchhiking or whatsoever, the law enforcement, that's an actionable offense, similar to what this would be. So law enforcement can put them in the car and say, I got to get you off the highway, or, you're not supposed to be here. It's the same thing. It's just doing it for those divided or accessible highways the same way. So as if that same right-of-way extended down the ramps and back up. And so it is, in particular in my district, I have two exits where the off-ramps are really narrow and tight, and so it's very, very difficult to keep those areas safe. We even had to post law enforcement officers there full-time during high-traffic areas just to keep people moving. So anyways, but that wasn't the intent of this at all.
Representative Griffey.
Thank you, Chairman, and thank you, Representative Chairman, for bringing this bill. And like Chairman Curcio, this is a public safety issue, and if we pass this legislation, this may in fact save somebody's life, because these high traffic areas, if a car swerves, isn't paying attention, they're texting on the phone or something, and they run over somebody inside one of these tents. I'd hate to think of that. And look, gentlemen, the state is running consistently, and ladies, it's running $100 million excess revenue collections over budgeted numbers. If we just took 1 month out of that and spent that on mental health issues in this state and people with homeless, I think a large part of the homeless population has mental health issues, I think we could really move the state of Tennessee forward. And I look forward to your other legislation on that, be willing to support that. Thank you, Mr. Chairman. Thank you.
Thank you, Representative. Chairman Howell.
Thank you, Mr. Chairman. And thanks to the sponsor for this bill. It's interesting that I have 2 state parks in my district. And I've had recent conversations with the rangers as well as the vice president of the chamber who's in charge of overseeing tourism. And we've had many conversations about this very issue and the growing need to get a handle on people who trash our beautiful state. And it's happening not just in my district, your district, but statewide. So I like your bill. I'm proud to vote for it. Thank you, Mr. Chairman.
Thank you.
Thank you. Leader Lamberth.
Move previous question.
Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 978 on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on. Thank you.
Thank you, Chairman, members.
Next item, number 6 on our calendar, House Bill 341 by Chairman Littleton. Motion. Have a motion and a second. You are recognized.
Thank you, Mr. Chairman. Under present law, the Tennessee Standardized Treatment Program for Sex Offenders requires that sex offenders submit to an evaluation for treatment developed by the Sex Offender Treatment Board. Sex offenders who require such evaluation and treatment are individuals who have been convicted of certain sex offenses, including rape, rape of a child, aggravated rape, solicitation of a minor, and sexual exploitation of a minor. This bill adds the following to the list of sex offenses that make a person subject to the standardized treatment plan as a sex offender: trafficking for commercial sex, patronizing prostitution for a person who is younger than 18 years of age or has an intellectual disability, and promoting the prostitution of a minor.
Thank you for that explanation. Any questions for our sponsor? Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 341 on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on. Thank you.
Thank you, Mr. Chairman. Committee.
Item number 7, House Bill 26. We are going to roll that to the Hill. Item number 8, House Bill 1388. We're going to move that to the Hill without objection. Item number 9, House Bill 1334 by Vice Chairman Baum. You have a motion and a second. You are recognized. You have a motion and a second on the amendment coded 004678. Is that the amendment you wish to proceed with?
Yes, sir.
Okay. You've been recognized on the amendment.
This General Assembly has done a lot of work to increase awareness for sex trafficking and human trafficking, and has done a lot to prevent these activities. Much of our work has been in schools with teachers and our students. This is a bill that would allow us an opportunity to work in a slightly different area. This bill would require the 19-member Tennessee Human Trafficking Advisory Council to develop an awareness poster that would be put up in our Tennessee Welcome Centers. Tennessee has 16 Welcome Centers where these awareness posters could be displayed, and the bill suggests that one of the places where consideration could be given for the display would be on the backs of bathroom door stalls. There are people who pass through the state who might have a moment of privacy in the restroom, and they could look at these posters to learn about the issue. The posters could contain our Tennessee hotline number and our state's webpage address that contains some information about this. This is exactly what some high school students in Rutherford County have done at several of the high schools and middle schools in my district. Happy to answer your questions.
Thank you for that explanation. Any questions for our sponsor? All right. Any objection to the question on the amendment? Seeing none, we're now voting on adding amendment number 004678 on the House Bill 1334. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We're now on we adopt or on House Bill 1334 as amended. Question has been called. Any objection? Seeing none, we're voting on adding House Bill 1334 onto full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail.
Thank you all.
Thank you. Let's go to item number 12, House Bill 733 by Representative Smith. You have a motion and a second. You're recognized.
Thank you, Chairman and Committee. This is a very simple bill. It reads exactly as it is printed. Thank you, sir. It is changing the definition that's currently in code from aggravated animal cruelty from depraved and sadistic manner to a very specified, objective, and measurable list that if someone knowingly commits the following, that they purposefully and knowingly kill, maim, torture, drown, suffocate, mutilate, starves, or otherwise causes physical harm or injury to a companion animal, that qualifies for aggravated animal cruelty. I have met with Farm Bureau on 2 occasions. They are neutral on the bill. This does not in any fashion apply to livestock. And with that, Mr. Chairman, I'll take questions of the committee.
Thank you, ma'am. Any questions for our sponsor? Representative Hardaway.
Thank you, and thank you, sponsor. I just want to be clear in my mind. It doesn't change any of the sentencing guidelines. It just puts some definition in place that brings clarity. So boom, 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 we've got specifics instead of a general description of the offense.
Thank you, Mr. Chairman. And yes, to my colleague, in talking to the senator who is the chief bill sponsor, Senator Lundberg, in his area, there had been a concern that in the court system, they had been bringing in social workers and psychologists to engage to define what is sadistic, what is depraved, and it added a layer of interfacing that sometimes it was just really a matter of needing some objectivity. And this is putting that objectivity into law so that it can stand up in court and there can be measurable behavior that applies. But to answer your question, sir, there's no change in sentencing.
All right. Thank you, ma'am.
Thank you
for the bill.
Yes, sir. Thank you,
Mr.
Representative. Any other questions for our sponsor? There is someone here that does wish to testify that we have on our list here, and Angela Schubert. Are they here? Okay. Without objection, sponsor, we are going to go out of session to hear. Yes, ma'am.
And if I could, Mr., I don't know this person. If they make sure to identify themselves.
They will. We will address that. Thank you. We're going to go out of session. We're going to hear from Miss Angela Schubert. If you will, as you come up to the microphone, you will have 4 minutes. You'll need to give your name, organization you're with, and then you'll have 4 minutes to have testimony.
I'm Angela Schubert from Morris Chapel, Tennessee. I have some questions about this law because you're using language that is in 202.
Ma'am, will you make sure that your microphone is on?
And if I could, Mr. Chairman, have her identify herself.
Yes, let's do this one more time, please, if you'll identify yourself for the record.
From Morris Chapel, Tennessee.
Okay, thank you. You may proceed.
Okay. So my question is, under the current law of 3914-202, 3914-212, and the Federal PAC Act, they all have the same overlapping language. However, your matter of devious harm to a companion animal, existing laws cover it. I oppose this 733 because I find it unnecessary to make alterations. We already have strict laws. According to Lundenberg's testimony on 316, the companion bill SB 166, it's hard to prove sadistic and depraved. However, I question how it would be easier to prove knowing or intentionally to do the same act.
Madam, I'm sorry to interrupt you, but if you would address your comments to the committee, please, and not the sponsor.
Did the same act, because 3914-202 uses the exact same language of intentionally and knowingly tortures, maims, and burns, but only poses a B misdemeanor. Would this language change would this change anything in 202?
Do you have any other comments?
No.
Okay. Members, do we have any questions for our guest? Seeing none? Okay, thank you. Thank you for your testimony. We'll go back in session. We are back on House Bill 733. Representative Griffey.
Thank you, Mr. Chairman. Thank you, Representative, for bringing this as a former DA. I know that the sadistic and depraved manner is always a little nuanced element that prosecutors have to prove, and this language will give it takes that sort of nuance element out of it and makes it clear this 1, 2, 3 is what you got to prove. I appreciate you bringing the bill, and I support the legislation. Thank you.
Thank you. Any other? Representative Howe.
Thank you, Mr. Chairman. And to the sponsor, just to clarify for my benefit, I may have missed it. It doesn't change the Class E felony. That's in place. Your bill just changes the language to describe what the offense is. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. That is correct. There is no change in the sentencing. This simply changes that one phrase, and rather than it reading in a depraved and sadistic manner, that there are specifics that are used to substantiate the allegation.
Thank you.
Representative Russell.
Thank you, Mr. Chairman. And just a question to the sponsor. A person that's charged under this offense would be considered innocent unless proven guilty in court of law?
That is our standard under the U.S. Constitution, absolutely.
Thank you.
Any other questions for our sponsor? I do have one question, if I may. Thank you. This is a very broad caption here in our code that this looks at. If there is an amendment, would you be willing to bring that back before this committee before we proceed?
I appreciate the chairman asking me that question. My office did receive an amendment, and we were mistaken to believe that it was delivered to us from the bill sponsor in the Senate, and we found out that that was not the case. And so there has been an amendment filed, but it will not travel with this bill. Anything moving forward will be deemed unfriendly. There is no intent on this sponsor's behalf to do anything other than to add a more robust definition, and that helps a prosecutor prove objectively what this crime is to be, not subjectively. So to answer your question specifically, another amendment that would make this more broad, applying to other types of animals, would be inappropriate.
Okay, thank you. Any other questions? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 733 on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full. Thank you.
Thank you, Chairman and Committee.
Representative Griffey.
Mr. Chairman, as a point of personal preference, is there a way we could possibly take up House Bill 802 just to get testimony, if no other reason? I've had people travel 2 hours or more to be here just to give their testimony.
Yes, sir. I have got a time allotted here towards the end of this committee to take care of that for you. Thank you.
Thank you, Mr. Chairman.
Item number 14, House Bill 545. You have a motion and a second. Chairman Dixie, you recognize you have two amendments traveling with your legislation. Amendment number 1004229. Do you wish to proceed with that amendment?
Yeah, I can't. I don't have it in front of me. Can you just?
There's a motion and a second on the amendment. Does it rewrite the entire bill? Was you able to pull that amendment up?
No, I do not have it. Oh, I'm sorry. The amendment is, do you have 4229?
Yes, sir, that's the one we have.
Okay.
You wish to proceed with that amendment?
Yes.
We have a motion and a second. We're in the proper posture. You can proceed with explanation on the amendment, please.
I apologize for that. When you said two of them, that threw me off because I was only aware of one.
Okay.
So this bill, what it does two things. One is it just changes the name. It humanizes our incarcerated individuals, and it changes the word from defendant to incarcerated individuals. What it does is, because technically once they're finished with their court case, they're not defendants anymore. They're incarcerated individuals. And if we're going to work to reform and change the stigma of what a felony is and try to get them back incorporated into society, this will go a long way as far as building the morale for the actual incarcerated individual. The second thing it does, it states that they, within the 1 year of the red date, their release eligibility date, that they should have their parole plan, the release plan in place. I'm going to give you an example of some things that happened. I had two brothers that were incarcerated. One, his red date was in July. One was in October. The one in October got out before the one in July because the one in July had to take some classes that were not offered at the prison that he was currently in. So he had to wait until that prison had some availability. He'd get transferred. It was a process. But by knowing that he had this a year ahead of time, this could have been solved and he could have been released on time. This will save the state money, taxpayers' money, and with that, that's my explanation, sir. I'm staying ready to answer any questions.
Okay, thank you. Any questions for the sponsor on this amendment? All right, seeing none, we're now voting on adding amendment code 004229 on the House Bill 545. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We adopt. There is a second amendment, Mr. Sponsor, coded 005306. There's a motion and a second on that amendment. Question has been called on the amendment.
Mr. Chairman, I think it might be proper to let him speak on it.
Yeah, well, I'm not familiar with that one. That's only new to 4229.
Chairman, it has your signature on it.
Oh, I think
it changes a few words around.
Yeah, I think that's what it does. It's the same amendment, but I just think it has the same. It was getting Section 1 and Section 2 together. So with that, I'd like to proceed.
Chairman Curcio.
Thank you, Mr. Chairman. And Representative Dixie, I noticed something here and wanted to be of assistance if I could. I need to make an oral amendment before we adopt this. Otherwise, we will delete what you just did. So my oral amendment is to change where it says Section 3. We need to change that to Section 2.
Correct.
Thank you.
Question on the oral.
Question called on the oral amendment. Those in favor of attaching the oral amendment say aye. Aye. Those opposed, no. The ayes prevail. We adopt. And so now we're on Amendment 2 as amended. Question has been called. All those in favor of attaching Amendment 2, 5306 on to House Bill 545 say aye. Aye. Those opposed, no. The ayes prevail. We adopt. We are now going to roll amendments number 1 and number 2 into one amendment without objection. Question has been called on the bill. Any objection? Seeing none, we're now voting on House Bill 545 as amended, sending on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full criminal. Thank you. Item 15, House Bill 563 by Chairman Dixie. You have a motion and a second. There is an amendment here coded 004278.
Yes.
You have a motion and a second. You wish to proceed?
Yeah, so that amendment makes the bill. Yes.
Okay, the amendment makes the bill. Please, we'll adopt the amendment if it's the will of the committee, and then we'll let you explain it if it's question's been called. Any objection? Seeing none, we're Now voting to adopt amendment number 004, 278 onto House Bill 563. Those in favor say aye. Aye. Those opposed, no. The ayes prevail. We're on House Bill 563 as amended. You're recognized.
So currently in state law, where you can write 10 times the limit that you put up for capital. So currently, for a simple explanation, if you put up $100,000, you can write $1 million worth of bonds. They give you $1 million worth of capacity. So what's happening, and it's not really necessarily due to COVID, but it's just the way that we're proceeding going forward. The courts are moving slower. They're not seeing as many cases. How a lot of bail bondsmen make their money is by turning over cases they get disposed of. So a lot of general sessions cases last maybe 3 to 6 months. But with the onset of pretrial, they're taking a lot more of those pretrial cases and letting people off on R&R, which is a great thing. They're not keeping them in jail. That's fine. So what it leaves, if the more riskier cases, which are the felony cases, which sometimes can last from anywhere from 36 months to 60 months. So what that does, it ties up the capacity of a bail bondsman. So this bill would increase it from 10 times to 20 times to give them a little bit more flexibility, and it's more of an economic bill to help maybe get more people out of jail, because in some of these small towns, they only have a couple of bondsmen, and especially in Tipton County, that their capacity is there. So it's not that they won't get them out of jail, they just don't have the ability to, but this will give the bail bonding companies a little flexibility. So with that, I stand with my explanation and ready to answer any questions.
Thank you. Any questions? Chairman Farmer, good to see you.
Yeah, thank you, Mr. Chairman. I apologize for being tardy this morning. One question. Have you thought about the situation to where a bail bonding company may become overextended on this situation?
So these are monitored by the courts. So like, for instance, whenever I get ready to make a bond, well, right now we all have to do a semi-annual report twice a year, so the courts know exactly where you are and how much capacity you have. So this will still be collateralized by that. So it's not that you won't be able to do any bonds or get overextended, because the courts, the judges monitor this as we go. So if you were to do a big bond, let's say you had a $100,000 bond, in most instances, most judges ask you to come in, they want to see your capacity, see where you are before they move on. So there's some stop gaps in place for that.
No, thank you.
Leader Lamberth.
Good bill. I think you've amended it in a great spot. I would like to ask, and you may not be aware of this, do you know the status of this in the Senate?
I do, but we do not. I've heard many times from a lot of my colleagues, what they do over there doesn't affect what we do over here, right? So this is one of the times that I need us to make sure we do the right thing and we lead by example and show them the error of their ways. So thank you for bringing that up and giving me the opportunity.
Mr. Chairman. Mr. Chairman, we hear some really good speeches in here. It did get summer studied in the Senate, I think, very recently. And that's a heck of a speech, and I appreciate it. But I will say we normally do not proceed if something is not going to be able to proceed in the Senate. I don't know the will of the rest of the committee. I'm comfortable voting yes to at least get you to the full committee if you could tell us that you would at least park it there and not bring it all the way to the House floor if it truly isn't going to proceed in the Senate this year. It's entirely up to you, but it's not one of those things that looks like it's going to proceed. You've worked very hard on this, and I think moving forward and leading in the House and making it clear to the Senate that you can proceed here, but moving beyond, and that's more a question for the full committee chair as to how he feels about it, but I mean, moving beyond the full committee in the House would probably wind up in just kind of a lot of other bills potentially getting to the floor that weren't proceeding in the Senate as well. So just a thought, but I wanted to at least bring it up. And again, well sold, regardless of which way it goes. So thank you.
Well, thank you. I appreciate it. I think there is some work that we still have some meat on the bone over there in the Senate that we could work something out. So I would appreciate if we could move to full and give me a little time to work on it.
Representative Moody.
Thank you, and thank you for bringing it. And of course, you know, my good friend and constituent Ernie was here and had to step out. But yeah, let's vote on it, because my constituent came all the way from Tipton County, and it's a good bill.
All right, previous question. Question has been called. Any objection? Seeing none, we are now voting on House Bill 563 as amended. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full criminal. Item 16, House Bill 972 by Chairman Dixie. You have a motion and a second. You're recognized.
If I could I I want to take this bill off notice for right now.
Okay. That objection off notice. Item 17, House Bill 1084 by Chairman Dixie. You have a motion and a second.
I see the look, but I want you to give you my explanation first. And, we understand that a lot of misdemeanors, they may go, when someone has a warrant, it can be active for 5 years. Some people don't understand. They may not realize that they have a warrant. This bill keeps the warrant active for 5 years. Current statute keeps the bill, the warrant active for 5 years. This bill would reduce it down to 1 year. Because really most misdemeanors are punishable by 1 year in jail or probation or whatever you may have you. But also the statute states that after the bill becomes active, it's only a statute of limitations is 12 months. So there's some ambiguity in how we interpret this. I think that this is a good time for us to kind of work on this bill to get it together. I've talked to a lot of stakeholders. I think there's some room for negotiation here. I have a lot of good things going on with this, and I think it's going to help a lot of people because it will also help reduce the interactions with police. And a lot of the things that we've seen that happened across the country always starts out with minor infractions and it escalates. So if we can work on this to get it together, I think we have an opportunity to really do something for public safety and help our citizens. But what I would like to do, if I could, Mr. Chairman, could I roll this for 1 week so I can have some more conversations?
Okay. Without objection, we'll roll 1 week.
All right. Thank you.
Members, if you will, we're going to take another trip down through the calendar. Let's run down to item number 44. Let's run down to item number 44, which is House Bill 361 by Vice Chairman Russell. You have a motion and a second. There is an amendment 004563. Do you wish to proceed with that amendment?
Yes, Mr. Chairman.
Okay. Motion second on the amendment. Recognized.
Thank you, Mr. Chairman. The amendment makes the bill. It will allow pets that are abandoned to be rescued as long as an officer of a governmental animal control agency is entering the property of a dwelling, has one of three reasons, and that's a valid search warrant, a judicial recognized exception to the warrant requirement, or the property owner's consent. Unfortunately, some pets are left behind after their owners move, and they will die locked up without water and or food. This bill will allow those animals to be rescued while ensuring no Fourth Amendment issues are violated.
Thank you for that explanation. Any questions for the sponsor on the amendment? Question's been called on the amendment. Any objections? Seeing none, we're now voting to add amendment number 004563 on the House Bill 361. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You adopt. We're on House Bill 361 as amended. I will say that, Mr. Brockton, there is testimony on this bill. Before we proceed any further, we will, without objection, go out of session. We're out of session to hear from Angela Schubert. Ma'am, if you will please introduce yourself, organization you're with, and you'll have 4 minutes to make a statement.
Angela Schubert from Morris Chapel. The amendment I had no notification of. Does this allow, you said it is going to allow for law enforcement a warrant before entering the property?
I'm sorry, would you repeat that? I'm sorry.
The amendment, I do not have, it was not in print, the amendment. So it does allow for a warrant to be exercised prior to entering the property.
We will, we're out of session, so I'm going to ask Legal Services if you would please answer that question.
Michelle Fogarty, Office of Legal Services. The amendment as written states that an officer of a governmental animal control agency may enter a property or dwelling and rescue any abandoned non-livestock animal therein if the entry is pursuant to a search warrant, a judicially recognized exception to the warrant requirement, or the property owner's consent.
Okay.
Thank you. Does that answer your question?
Yes, sir.
Okay.
The other thing is I have discovered in 207, it allows for, the biggest thing with the bill prior to the amendment was the going into dwellings, private property to confiscate companion animals without a warrant. And 207 permits, because there's no definition of abandoned property, there was no definition of what rescue was. And there's actually existing law 3914-207 that allows you to go in and feed or water prior, so you could at least do that for something to get a warrant with a actual officer, law officer. So this does make the amendment for a warrant prior to entering a property.
Ma'am? Yes,
Okay.
that's my understanding, yes.
All right.
Any other questions? Any questions for our visitor? Seeing none, without objection, we go back in session. We are back on House Bill 361 as amended. Any questions for the sponsor? Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 361 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on. Thank you. All right. Back down the road to item number 19. Before we take up this item, I want to let the committee know and those that are here, we have two pieces of legislation before us today that we are going to hear testimony on. We may not take any action on those bills, but we will have testimony on those, and so we will take up a few more bills, and then we will get to those points. We're on item number 19, House Bill 994 by Leader Love. Motion. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman and committee members. This particular piece of legislation is to create a violence interrupters program. I want to read you the text of it, if I can, very quickly. Sorry for the delay here. As introduced, creates the Tennessee Violence Intervention Program with the Department of Criminal Justice Programs in Finance and Administration to invest in evidence-based violence reduction initiatives. So when we talk about violence interrupter programs approach violence from a public health perspective. An example of one of these programs is called Cure Violence. Cure Violence's founder and executive director, Gary Slutkin, is an epidemiologist, and he says that if we approach violence from a health perspective, it allows us to reduce violence in neighborhoods. And what they do is they go out and recruit persons in the community to reduce violence in the community by talking to persons who they know are going to be engaged in these activities. It reduces the amount of violence in the neighborhoods. It is evidence-based, and it also reduces the amount of time that law enforcement has to spend on reducing violence because it's a neighborhood initiative. And another program is called Operation Safe Streets. It has four major components: a review of implementation data for the program, an analysis of the effects of the program on homicides and non-fatal shootings, and a community survey of attitudes toward gun violence, and interview with these persons after this. So this is evidence-based programs that use the community to reduce violence in their own neighborhood. And so I'm simply asking that we would consider this piece of legislation to allow us to create the same type of program here in Tennessee to allow persons to apply for grants in the Department of Finance and Administration through their already established criminal justice programs, and then be able to establish violence interruption programs in Tennessee.
Thank you for that explanation. Any questions for our sponsor? Seeing none, question has been called. Any objection? Seeing none, we're now voting on sending House Bill 994 on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on. Thank you.
Thank you, Mr. Chairman and committee members.
Item number 20, House Bill 995 by Leader Love. Have a motion and a second. You're recognized.
Thank you, Mr. Chairman and committee members. This is a very good piece of legislation. I want to let you know that. This bill has been brought before you in previous years and actually addresses an issue about the duality of time between misdemeanors and felonies when it speaks to the amount of time a person has to wait before they can apply for expunction of their record. Current law, as of today, March, all right, today, current law says you must wait 5 years before you can apply for a expunction of a misdemeanor. You also must wait 5 years of no issues before you can apply for expunction of a felony. So this bill does not affect anything with the time frame for felonies. It only deals with non-violent misdemeanors. I think that if a person has served their time, which is usually 11 months, 29 days with a misdemeanor, that they shouldn't have to wait 5 years before they can apply for expungement. This simply says they have to wait 3 years, have no offenses for 3 years, and then be able to apply for expungement of their records. Again, it does nothing with felonies. It does not change the amount of time for felonies. It doesn't deal with violent misdemeanors, but simply with non-violent misdemeanors. So again, I would ask for your support, and I'm open for questions.
Thank you for that. First on my list is Leader Lambert.
Thank you, Mr. Chairman. And my friend, we've gone through this back and forth before. Your intentions are pure. I completely understand the reason why you're bringing the bill, but 5 years is a reasonable amount of time as well for someone to prove to society that while they have been convicted of a crime, misdemeanor or felony, that they've gone 5 years and behaved themselves, haven't been arrested or convicted of anything else. And when they've proven that they have, not only can they have one misdemeanor, but Chairman Curcio has carried bills in the past and others that, and Senator Ackberry, which I think is your co-sponsor in this bill, we've all worked for years that they could even have 2 misdemeanors or a misdemeanor and felony. I mean, there's multiple opportunities there to get your record cleaned up, but to wait 5 years and to prove to society that you have changed your ways, to me, seems very reasonable. Lowering it to 3, just does not seem appropriate at this time. So while I, again, dearly respect you as a sponsor and deeply appreciate you fighting for your community and your constituents, I'll have to vote no today, but I appreciate you bringing the bill back again this year. Thank you.
Thank you. Any other questions for our sponsor? Chairman Farmer.
I know it's kind of hard to see through the plexiglass here, and also I want to remind people that if you're in a situation where you're waiting 5 years, this isn't your first offense. If it would have been, you could have entered into a deferred plea, which you've been on probation for 11 months, 29 days, then it would have been dismissed. So I think I'm going to concur with Leader Lambert that 5 years is a reasonable time. Thank you.
Representative Hardaway.
Thank you, Mr. Chairman. And, I don't think there's ever a cookie-cutter approach to justice. And there are individuals who could very well be prepared to move back into society with full dignity returned by having the expunctions. And from the way that I interpret the bill, Mr. Sponsor, it doesn't stop the scrutiny of the courts in evaluating the worth of the expunction application. And there are folks who it might take them 1 time, others it might take them 2 times, and then we've got those it might take 3, 4, 5. But there are folks who can figure out how to be better citizens in less than 5 years. And quite often, I'll suggest to you that that 2-year difference in income and opportunities to create economic stability, not only for themselves, but their children. We know that there's any number of studies, empirical evidence that suggests that those children of men and women who are engaged in the system are more likely to go into the system. So let's intervene as soon as we can to restore these folk, unless we have evidence to the contrary, I think it's worth the shot to see how 3 years, and you look at how it fits with the rest of the offenses that are eligible. I think it's worth giving it a shot. So I'm voting yes for this, Mr. Sponsor. And I thank you for your foresight, and hopefully I've provided some insight.
Thank you for that, Vice Chair Russell.
Thank you, Mr. Chairman. I also have a concern about reducing it from 5 to 3 years. I would like to clarify, is this expunging the conviction or the arrest or both?
This is expunging the record of the conviction.
Thank you.
Yeah, and the arrest, I'm sorry. Conviction and the arrest.
Any other questions for our sponsor? Seeing none, question has been called. Without objection, we're now voting to send House Bill 995 on the full criminal. All those in favor say aye. Aye. Those opposed, no. The noes prevail. The bill fails.
Thank you, Mr. Chairman and committee members.
Thank you. Representative Hardaway. Oh, I thought you were waving for me. You wanted to speak. I'm sorry.
No, sir, I've had enough.
Okay. Members, we are going to jump ahead here a couple places to item number 23, which is House Bill 39. You have a motion and a second. What we'll do here, if it's the will of this committee, we'll allow Representative Freeman to make a few remarks. He's got 2 guests that we would hear from today. We'll go out of session to do that. As we come back in, there will be no debate on the merits of this bill. We will not take any final action today, but we will hear from those that are here to testify. Is that okay with you, Mr. Sponsor?
It's whatever you decide.
Okay, thank you. All right. So you're properly recognized. Please proceed.
Thank you, Chairman. Thank you, committee. If I seem a little nervous, it's because this is something I've been working on for a good 3-4 years. It's the first bill I filed when I got elected. And I named it after the person I worked with, Jim Coley, to get this passed. I can't overstate how important this legislation is going to be. We're all aware of the backlog of untested rape kits that we saw in Tennessee several years ago. It's a problem across the nation. And the solution that other states have come up with is to put a tracking system that allows the victims and the survivors of rape and sexual abuse to be empowered to know the process of their kit. I've worked with all the stakeholders, TBI and others, to get this in a posture that they are supportive of. And I'm excited to present it. I'm not sure exactly what you want me to do. I do have an amendment. You don't do any of that?
No, sir. We won't take up any of that.
So with that, I've got 2 people I'd like to give some testimony.
Okay, sounds great. Members, without objection, we are going to go out of session. Out of session, we have 2 here, a Jordan Kimmel and a Michelle Kuiper. I'm sorry. We will, both of you will have an opportunity to speak. You'll have 4 minutes apiece to speak. Whoever goes first, if you would, you turn your microphone on. You introduce yourself and for the record, and then you will have 4 minutes. Should be a red button there.
Is it okay to take off my mask?
Yes, absolutely.
Okay, great. Hi, good afternoon, Chair Doggett and committee members. My name is Michelle Kuiper. I'm honored to be here today representing the Joyful Heart Foundation. It's the nation's leading organization working to eliminate the rape kit backlog. We're so grateful for Representative Freeman for partnering with us over the last 4 years on this essential effort and for championing HB 39. Joyful Heart was founded in 2004 by Law and Order, SVU actress, director, and advocate Mariska Hargitay. Since 2010, we have made eliminating the nation's backlog of untested rape kits our top priority. In 2014, Memphis alone had more than 12,000 untested rape kits. But the good news is the state has made progress on rape kit reform. Tennessee has rape kit testing laws, but how do we know that if they are being followed? Tracking systems are crucial to holding hospitals, law enforcement, and labs accountable by monitoring if they are following the state's laws. In addition, a tracking system would allow for survivors to follow their kit through the process. With technology today, you can track your purchases on Amazon and know where it is at all times. All we are asking is that the victims would be allowed to do the same. 30 states and DC have online tracking systems. HB 39 would create a new victim's right, the right to know the status of their sexual assault forensic exam, otherwise known as a rape kit. After having a long, extensive forensic exam, survivors go home in trauma, and tragically, most are never contacted about the status of their evidence. This is detrimental to the passage of their healing. Joyful Heart's research in 2016 found that access to information can counter the loss of control that is at the core of the sexual assault experience. 24 states and Washington, D.C. grant survivors the right to know the status of their kits. Survivors in Tennessee should have the same right. HB 39 also speeds up rape kit testing by shortening timelines for rape kit submissions. Tennessee has one of the longest timelines of 33 states to submit rape kits to the lab, allowing dangerous offenders to stay on the streets longer. With HB 39, the Tennessee legislature can bring greater accountability to the rape kit handling process, and this will send a strong message to survivors that they and their healing matters. Thank you so much for your consideration today.
Thank you. Thank you very much. Ms. Jordan, you introduce yourself. You'll have 4 minutes for testimony.
Hello, my name is Jordan Kimmel. I am from Rice. Being raped at 18 years old while enrolled in college comes with unique challenges. We are at the cusp of being considered an adult, but our childhood innocence is still right behind us. We have school, work, clubs, internships, friends, sports, and dreams. Today, I am less than 6 months away from the 3-year minimum statute of losing my rape kit. I testified before this committee a year ago today for Representative Jim Coley's rape kit tracking system bill. I told you I'm a student at Vanderbilt. I told you I wanted to be a doctor since I was 8, but I have now chosen a different path to fight for victims of crime in court. Sexual violence does not have a race, color, religion, national origin, or sex. It does not have an age, political affiliation, socioeconomic background. Sexual violence is not limited by geographic location, and even though we may try to put ourselves into categories and create distinctions which may or may not be necessary, it is an issue that affects us all. Too many activists allow anger and resentment to be their driving forces. Often you are the targets of their rage. As an activist of my generation, I want to rise above the hate and keep the legacy of Dr. Martin Luther King Jr. alive. The brilliant idea of the speech, "I have a dream," can be used for many social justice issues, and it can also be used as a platform for combating sexual violence in the United States. I have a dream that Tennessee will uphold its Constitution to preserve and protect the rights of victims of crime to justice and due process. I have a dream young girls and boys will be free from sexual abuse at the hands of a caregiver or principles of authority. I have a dream that one day an underage victim under the influence will be able to come forward without fear of being prosecuted for a crime he or she may have committed at the time of the assault. I have a dream that Tennessee will be able to track sexual assault kits so that victims never lose sight of what's important. I have a dream that healthcare facilities will tell victims what their hold kit tracking number is, where their kit is located, and the procedures for making a police report. I have a dream that the college students of today will be able to come forward when they are grown to face their assailant with a 10-year preservation of hold kits. I have a dream that we can make freedom ring for survivors here in our beautiful state, and we can make Tennessee the epitome of the American dream. Representative Jim Coley understood that dream, and if he was still working in this building, he would certainly tell you that himself. Being a rape victim while enrolled in college is incredibly difficult, so I hope to inspire you all to think of what Tennessee can be for the next generation of survivors of sexual violence like me. Thank you.
Thank you. Thank you both for your testimony. Members, do we have any questions for our witnesses? Yes, sir. Representative Sexton.
Thank you for coming today and sharing your story. I have one question that I apologize, just don't understand. You said that you were 3 years away from losing something. I just want you to clarify that.
The 3-year minimum statute, June is starting my 3-year mark of when Sumner County Police Department could possibly destroy my rape kit.
What do you mean that they could destroy your rape kit? And I apologize, I just don't have any knowledge of this, but I am interested.
Thank you, Mr. Chairman. I believe they're not required under current law to hold it any longer than 3 years, so it's not a guarantee that that rape kit would be destroyed, but I think what our witness is testifying to the fact is that obviously that's very troublesome if that's your kit and you know that they potentially could destroy it. This bill would seek to change that, among other things.
Thank you, Chairman, and thank you for that clarification. And this is all new to me, so forgive me, but your story certainly touches our heart. And if there's anything that we can do, I think that we certainly should. You deserve to have a speedy end, if it can be. But we should never give up on you and as a victim, and I don't think we would do that. I don't have enough information myself to make a judgment one or the other. I'm not an attorney. A lot of these are, but I am signed on to the bill because I believe in it, even though I don't have the information. And so God bless you. Godspeed to what you're trying to do, both of you. And let's do something in behalf of our victims. Thank you.
Thank you. Any other questions or comments? Representative Hardaway.
Thank you, Mr. Chairman, and good morning to you ladies, and thank you for being here. That's an awfully strong message that you bring, and you phrased it so eloquently, and it just puts me in the mind of the legal maxim that justice delayed is justice denied. And then I reflect on the preamble, we the people of the United States in order to form a more perfect union, establish justice. And we're not doing that. If we're not giving a timely and speedy resolution to you as the injured party, we're not fulfilling our constitutional obligations. The legislature is in a position to do so. The sponsor has brought us that vehicle to make it happen, and I appreciate y'all being here. That's some amazing story that you have, your dedication, not one of pity for yourself, but one of taking your skills, your blessings, and translating those, taking that talent, that God-given talent, and developing the skill set to help others. That's admirable. It's a noble mission that you've chosen. I salute you. And I'm supporting your bill, Mr. Sponsor. Thank you.
Thank you, Representative. Without objection, we're going to go back into session. We're back into session. Thank you, ladies, for being here. Members, we are going to roll this bill to the heel of today's calendar. Yes, sir. We have two amendments. Amendment 005675. We have a motion and a second. Question's been called. Any objection? Seeing none, we're voting to adopt 005675 to House Bill 39. All those in favor say aye. Aye. Those opposed? The ayes prevail. You adopt. We also have Amendment Code 005217. Motion and a second. Question's been called on the amendment. Any objection? Seeing none, we're now voting to adopt Amendment 005217 on the House Bill 39. All those in favor say aye. Aye. All those opposed, no. The ayes prevail. We adopt. Now we'll roll both of these amendments into one without objection. Rolled into one. Now we're on House Bill 39 as amended. Question has been called. Any objection? Seeing none, we're now voting on House Bill 39 as amended. Those in favor say aye. Aye. Those opposed, no. The ayes prevail. Congratulations. You move on to full criminal.
Thank you, Chairman. Thank you, committee. I'd like to take one quick personal privilege. Mr. and Ms. Kimmel here to watch or to listen to Jordan testify, so I'd like to recognize them for coming today.
Thank you. And I would like to say, Representative Freeman, that you have been working this bill very hard over the last, well, for a good while. And so I didn't want to give the impression that we were speeding through something. This is something we've all been very studious over the past several months. So thank you for your work on that. We look forward to seeing you full criminal. We're going to skip ahead now to item number 45. Item number 45 on the calendar, House Bill 802 by Representative Griffey.
If I could get a motion and a second, please.
You have a motion, you have a second, you are recognized.
Thank you, Mr. Chairman. This is the Domestic Violence Survivor Support Act. I do not wish to proceed forward. I just have testimony from one witness who drove 2 hours to be here today. If we could.
Thank you very much. Without objection, we will go out of session.
And, Mr. Chairman, members of the committee, this is Amanda Allen, who lost her sister to domestic violence. And I also have Elizabeth Jones, who's here. She lost her sister to domestic violence. And I have another case in my district, Chanton Clay, who lost her sister to domestic violence. So,
okay. We have on our list Amanda Allen. If you would come up, you'll have, introduce yourself, and you'll have 4 minutes to speak to the committee.
No disrespect. I just want to clarify, I'm not the sister of a victim. That's okay. I am the actual victim. He is naming the bill after Amanda Mercer, who was also my friend. And I am now eventually going to marry into her family. So those are the lines here. I just wanted to say my piece here and hope that you will bear with me and understand my point of view. Domestic violence is terrorism. If you find out the location of a terrorist, do you just let him go, forget about it, or do you watch him, where they frequent, who they associate with? These are narcissistic sociopaths and psychopaths. They lack a conscience. They are a danger to others and even themselves. They commit attempted murder, assault with a deadly weapon, but since it is against a supposed loved one, it is cast under the umbrella of domestic assault. Therefore, these repeat offenders are allowed to bond out of jail, and just where do you think the first place they go is? The violence escalates, and as we have seen, even to murder, double murder, and suicide. For someone who has only even witnessed a crime by a violent offender, there is protection options, witness protection, and tracking on the offender, but not for domestic violence. These perpetrators have to have control. The victim is simply an object to possess, and children are merely a tool or a weapon or just in the way. They stop at nothing, and if they can't have you, no one can. They manipulate, abuse, and terrorize their victims to where you cannot even function because of the fear. You answer for any inconvenience they may encounter. I myself am a survivor of 16 years of abuse, assault, and matrimonial terrorism. My daughter and I both jump at shadows. I have been diagnosed with CPTSD because of the continued abuse. My daughter has severe depression, anxiety, and is afraid of the male population as a whole. If this bill is passed, it is finally a step in the right direction. Law enforcement can monitor their location, see where they frequent, and even prove their location when a crime occurs, which can also prevent instances like where my friend was murdered, another friend beaten unrecognizably just a week ago, and in my own differences. As of right now, I personally know of at least 4 people who are in hiding from their abusers, either now or in the very recent past. A piece of paper stating an order of protection is not enough, especially when it can be hard to obtain under some circumstances. My own abuser is currently incarcerated for arson against mine and my daughter's personal belongings, and another domestic assault charge against yet another victim. A GPS tracker would at least show or prevent him from stalking us, or worse. Please, we're asking you to help us, all of us.
Thank you, ma'am, for your comments and for being here with us today. Members, do we have questions or comments for our witness? Yes, sir, Mr. Griffey.
Thank you, Mr. Chairman. I just want to thank Amanda for coming today and recognize her parents who are also here to support her and all the survivors of domestic violence. So thank you very much.
Thank you.
Thank you. We will, I do want to say this. I'm sorry, due to time constraints and to our previous guest that we have on that other legislation, we didn't have an opportunity to proceed forward. But I did want to say, again, thank you very much for being here with us today, and you're welcome back at any time.
Thank you.
Thank you. Okay, without objection, we're going back into session. Representative Griffey?
Mr. Chairman, may I roll this bill to next week?
That's not going to be a need, sir. I'm going to roll it to the hill of the calendar, and in a few moments, I'm going to take care of that.
Thank you,
So without objection, roll to the hill of today's calendar. Members, all bills that were not taken up today will be rolled to next week's calendar. We are now adjourned. Thank you. Is that how you do it?